the ex-wife actually believes that being awarded guardian over her ex-husband gave her license to sell all the property and do anything she wanted to with the money that came in. She doesn't understand that being awarded guardianship didn't give her ownerships and benefits. It gave her duties and obligations. And she may be very, very unhappy with that position that she thinks she obtained if she squanders all of the proceeds of the property that she's selling, to which she is the guardian over her ex-husband. However, it should appear that if the ex-husband does this process right with that court, he should literally be in a position to go back and receive back his competency and to receive back the property that he is entitled to. Yes, Lee?
It was last week, yes, it was last week that we had discussed out a similar situation between fathers and mothers. Instead of real estate, we were talking about children, but it reflected the same thing, and I thank you very much for your comments and those that attended the meeting, because we were able to go back through what the decree of that court was, because that court had put together a decree based upon a bunch of arguments being presented by attorneys for the state acting in response, and including something that occurred, and that is the father and the mother had a private session with the judge. And I had been the observer of the hearing, except for the private session, and I heard what the private session was. I went back to my letter rogatories where I responded to the court, and that is where, in the private session, that the father had said to the judge, well, if she gets custody, I want guaranteed visitation. And, of course, I tried to patch that up in letter rogatory. And, by golly, that's what he received. And we looked closer at the judgment, and Jack, she is responsible for all costs of visitation. The fact that she had moved was covered by the father saying, you know, if she gets custody, I want visitation. So that was, you know, after the review, and I appreciate the overview on this, and I said, okay, he's going to be responding. I mean, he's going to be saying, okay, you got custody, you got it. And he's going to be relinquishing everything about the children and go ahead and set together what the court had decreed, a schedule. And his argument of she had moved 100 miles away, that went away when he said, if she gets custody of these two kids, I want visitation. So,
and that's what the court said to him to do.
Yes.
To schedule visitation.
And he spent a year arguing about the 100 miles, and he did everything correctly, except now we're down to this issue. I think we can get it settled. The second situation was one of the officers of the court, he was paying a fee to speak in the court. He paid on every single letter of invoice that officer of the court sent for his services. The officer of the court then added everything up he had paid and reissued another bill to him to pay it again. Well, he almost did everything right on this issue. He did the acceptance and the whole thing, and he brought all that into a court. And the magistrate had everything going in favor of the father, except, again, he did the same thing again. He said, Well, if he ever sent me a bill, I would have paid it. So the court has sent him a bill. And they did, since it was in equity, and they never could get it resolved because he didn't do a counterclaim. He just did everything correct, but he did make the confessional statement. They split the monies that this officer of the court was double dipping. They split it in half, just like the baby. They gave both halves of both pieces. There you go. The only funny part was, of course, the little trick in this, because don't forget the magistrate, and they're all winky-winky, they all belong to the same country club. They started to charge the father interest on the money he owed back into March when the hearing was. Cleverly, what they did was, the hearing was on the 7th, the decision came out on the 14th, and he received it today. Now, we counted up, okay, that's 90 days. All right? So, he's going to respond by, he's going to pay that amount. He's going to date the check on March 14th. Send it to him. There's no interest. He's done. See, he got what he asked for. Twice in a row. I mean, what he was doing was responding to the public education we all have. That's our built-in public education.
Yeah, look in the mirror. Be careful what you ask
That's
for.
right.
You just might get it.
Both times I went to my knees and going, why do I try to help? Both times I answered the situation, the letter rogatory, and I knew it was like, ha-ha, high five, we got him. I had to admit to the mistake. I mean, I did at least that much for the people when they couldn't. It cannot be that kind of mistake is, you're not going to. I'm not sure how we can correct a mistake like that. I just don't know the procedure, but at least we put it out there. So twice this person had used the same phraseology. If this is going to happen, then I want this. Same thing, and we all do that. We all have a tendency to say, well, theoretically, what about this? And that's what we've been taught in our public education. And I'm not talking about public schools. I'm just talking about our general education. And that is not the place for it. These courts are just looking for that type of response. And this couple, they're really a nice people. They are super nice. They do not deserve what's been happening to them. But then again, they still are, no matter how hard they tried, they can't seem to drop that ability to testify. And I think that Jack goes through this all the time. Like, well, I don't really understand everything in this letter. And you want to say, there's a certain time you have to stop and think how much testifying you're going to do. And I know this young couple did the right thing many times by going into a court and simply saying, I'm not here to testify, I'm only here to present documentations as per the matter before the court. No matter what was asked. Same answer. Judge says, perfect answer. You can sit down. Now present your things. It was beautiful until the final comment. Well, if she gets custody. The judge goes, let's high-five on that one. We got right back to equity again. Bingo. He's compelled us to go back into equity. And so these classes and this theory is very, very important. The hard part is the implementing and the keeping in your head which way you're going on these things. And you can't, all the paperwork you're doing is not going to compensate for, what did they say in the Second World War? Loose lips sink ships, or your ship is going to go down. And I don't know how to get past that. I do not know the formula. I probably am as guilty about it myself, and I think even Jack would be guilty of that under the heat of battle. Sounds good. So we're going to have to do some training in your own mind, in your own heart, in your own thing. But that was my observations. And one last item. A fellow who had a situation with a couple states at about a police chase, and he tipped his vehicle over, And the policeman then said, "Oh, we all had damages." He made a whole bunch of mistakes in the process, but one of the things was he went through the felony thing and it was all dismissed, but he agreed to pay some dollars. And they go, "Oh, yeah, sure, neat trade." Well, they've come back at him for a civil. The remainder of the money to be charged in civil. Okay, can't get you in this. They're not talking about incarceration anymore. They just, nickels and dimes. So I told them this time, just keep going what you're doing. Do like you said last time, but, don't get down to where you're exchanging with them. Don't go start saying to the public defender, "Okay, here's what I'm willing to pay." Because you go right back in it again, and they may accept that, and then they go back into a felony court, and they says, "We still have another issue." So, I don't think you can. I think in the first situation, maybe some clarification if you try to, but I don't think they would accept the release. If somebody said, "This releases everything in all courts, in felony and civil." I have seen some contracts of the court like that, where they release everything. They said there is no more action. There can be no more further follow-up, no civil. This is everything. But I don't think O.J. Simpson even got out of that one, did he? He walked out of the criminal and walked right into the civil and decided, okay, fine. He got nailed that way. But these things are not that easy. They're really not that easy. But we're getting closer with the philosophy here of what you're actually admitting to. And that's very, very important. And then how to discharge that. And watch the hypothetical. Don't throw a hypothetical out there. Well, if they would have only did this, I would have done that. Because that's going to happen in a blink. That's all they need to hear. And I think that hypothetical stuff has been taught since we've been old enough to learn. That always is taught to us how to do the hypotheticals. And that's, I found in every hearing that I've been into, that's what goes down fastest when they throw the hypotheticals out there. Well, if they would have only not walked in front of my car, I wouldn't have hit them. Okay. Guess what? You just hit somebody. Not knowing what was going on. And so you got to be careful with those things. And I think the cases, what Jack's been going are excellent. I always wish I'd kind of like more local so I could observe the hearings.
Okay, thanks, Lee. What we have suggested to this daughter and her father then is to do exactly the opposite of what anybody probably a week or so ago would have ever comprehended doing in this case. And she sees exactly what we're doing here and its relationship to the court case that Solomon had going from equity to law is so straightforward in its relationship that she knows in her heart this is absolutely correct. Her father is in his 70s or 80s, and he's going to have a very, very difficult time understanding the logic of what he needs to do here to get this done. And so this daughter is going to have the biggest problem explaining to her father why he needs to do this process that we talked about to give him the remedy and relief that he needs to move forward in this case. Once you understand what the daughter and father are doing in this case in Indiana, then you can go back to the case up in Michigan and see exactly what the guy in jail up there has to do in his case. What does he need to do? Well, it's not a competency case mentally with him. Well, let's not talk about the notary right now. The notary really does not have any process in that case other than the mistaken assumption that he was part of a gang trying to rob Party B of all their interest in the property. And he can rebut that in a heartbeat with his negative averment affidavits and the concept that that he was just doing his job as required as a public notary. But let me make an aside here. I got a telephone call this afternoon from one of my acquaintances out in Oregon. And this woman told me that she has been told by another patriot out there that either the Attorney General or a high-ranking official in Oregon has allegedly put out a notice to all public notaries in Oregon that they may be criminally charged if they continue to do these certificate of protests, etc. Now, we've heard a lot of these kind of like crazy statements. And it's like, hello, isn't that what they're supposed to do under the Uniform Commercial Code? Under UCC 3, like dash 501 or something? And so saying that they're putting out an order which would criminalize their duty of doing what the code and what their professional practice tells them they need to do is very suspect to me. It could be nothing more than military war propaganda just to try to discourage things. It's kind of like saying we are not going to allow anyone to write bills of exchange anymore. I mean, like, hello, every check, every commercial process is a bill of exchange. So there's times when stupid statements come out like this, and you've got to research the background, see where they're going on. A lot of them could well be war propaganda. In any event, going back up to the Michigan case, the guy that's in jail up there charged with the substance of the problems, the biggest presumption is that he was trying to extort money. But the state's immediate problem and the substance of the issue that the state has is that there are two state records that are adverse to each other. And they have made the allegation of extortion to give them the legal foundation to eradicate the one filing. Just like in Indiana, the allegation of incompetence could be used to create a court order if the dishonor continues, that the party that filed the UCC did so with incompetence, which would give them a reason to strike that filing. So what does our hero in Michigan do to go into the proceedings in order to be the creditor and resolve every issue, public and private? Same thing. He takes his UCC-1 and he gives all the titles and all the property to Party B. If you're not willing to give it up, you can't ever keep it. And you were the last one to commit the dishonor, and it's because of you that the state has a problem and everybody else has a problem. So once again, we've got to stop this stinking thinking that because you do one private administrative process, that you don't need a second witness to get the public to certify it and okay it. Because everything that's being caused by my friend that's in jail in Michigan was based on the presumption that we in the private are sovereign and we don't let the stinking public tell us what we're going to do. That was his big mistake. That was the dishonor. And if he loses any claims, it will be because of his dishonor, not because he never had a claim to begin with. But to start out, it is not sufficient that he goes into the court and says, I've accepted it for value, I've returned it for value, I'm asking for settlement and closure, and if you don't give it to me, I'm going to tort you people because you're stepping on my rights. That's not the solution. So what he needs to do in substance is he not only needs to accept and return and ask for settlement and closure. How can he ask for settlement and closure until the substance of the problems have been resolved so that the closure becomes a simple administrative process based on what he tells them to do? And of course, at any time, the judge can then go, oh, good, well, fine, let's reverse this last equity decision. And remember, Hartford Van Dyke said that one of the tests for your credibility in commercial process was what? Commit 100% of your commercial liability to the process. How can you commit any more than 100% of the commercial liability when you sign over the UCC to the other party? That's what you're doing. If you're not willing to extend the losses, you'll never get the gains. You have to literally be able to bond it. And you talk about bonding, what these guys are doing by signing over the UCC ones, they're bonding it 100%. There's your bond in fact. Yes, Jim?
I was just wondering, aren't you giving up title then when you do that with UCC 3? Are you giving up all the rights that...
Absolutely. And remember, unless you give them up, you can't get them. It's all backwards.
So then you go back later and...
That's the funny thing. The statement was, then you go back later and fight again. No. Once you've given them up, how can you fight for them? You already voluntarily gave them up. Doesn't Scripture say, would it not be better that you lose all of that property rather than go back and keep warring with your brother endlessly? Number one, because it's not honorable to stay in warfare with your neighbor. It doesn't bring you to peace.
Okay, he's at peace, but he's lost everything.
Right. Now, question. Who has total control of that property?
Who do you sign it over to, no? Or the court does?
God does.
Oh, yeah.
Wasn't the death of the Messiah to purchase this world and all it was in it?
Yes.
So in reality, the Father in heaven has control of everything.
Right.
Does he not say in the Testaments that he even knows the hairs on your head and when a bird falls from heaven and everything else? Does he not cause it to rain equally on the good and on the bad?
Right.
If the bad take from you something that was rightfully yours, is there any way, shape, and form that the Father cannot restore it or many-fold more of it to you, if that be His will?
Right.
So why don't you put it in His hands?
I always do.
Now, understand this. We talked about the fact that those courts are an ecclesiastical court. They're just run by a priest in a black garb. And you don't picture them as being spiritual courts. But what would happen if the Father in heaven uses them as His agents? Many times He said, particularly in the Old Testament, that when my prophets and my priests do not follow my laws, that I will cause a cloud to come over their eyesight and their hearing, and they will preach stupidity, and the people will follow that. And then he said many times, I will teach them through the enemies that I bring in to place them in captivity, who are my agents. So these black-robed priests are the agents of the Father. If you honor them, you honor the Father who sent them. If you're resolving their problems, you're resolving the Father's problems. What part of you taking on the capacity of sovereign, creditor, and resolving these problems with the people of this world can't be recognized by your Father in heaven? And are you telling me He cannot bless you in some other way except you go out and go to constant warfare against these people?
You're right.
So is it not better to give your brother the shirt off your back and go out and let the Father provide for you another shirt if he thinks you're freezing?
Now, that's right, but now when it comes to the UCC1 and UCC3, I don't have anything to do. I think most of the people here don't have a UCC1 or UCC3. So when it comes to me or any of them, what would we do in a case like that? I don't have a UCC to give up. All I can do is give up whatever I have.
Okay, Jim has the question, what would happen to all the people that don't have UCCs if that's the problem? And yes, that could well be a problem. What does the UCC do for you?
It makes you sovereign, puts you...
No, a UCC does not make you sovereign.
Oh, well, it has, I guess it puts you in a category with the state that might be a little different than the average person.
It puts you in a category with the state that's a little different than the average person, is the comment. What the UCC, remember, the UCC recites public knowledge or gives the public knowledge of certain facts. That is the only purpose for the filing, to give notice that supposedly an agreement, a security agreement, exists in fact. But it usually does not contain the agreement in the filing. That's kind of like the IRS saying, we are giving you notice we have a lien, but we're not going to give you the lien or show you the lien. They're just giving you a notice. Well, that's what the UCC is doing. It's just giving a public notice of some fact. Remember, we're interested in facts because facts apply to law issues, and it displaces presumptions which create equitable relationships. And our job looking for truth is to turn an equity court into a court of law instead of the other way around. So the question is, what does the filing of a UCC 1 or 3 accomplish? The answer is, it is evidence that there are two distinct characters with the same name.
Okay,
so it shows a separation of two parties, the straw man and the living man, because it comes unrebutted out of the public.
Well, the fact that he owns that property is true, but the fact that he's going to give it up is also true.
You said the fact that he owns the property is true, and the fact that he's going to give it up is also true. Yeah. As far as the public is concerned, there is not a fact that he owns the property because there's two public notices of the opposite. All we understand is that there are two different sets of parties that have an interest in these lands, and we know that the first one dishonored the second one, and the second one dishonored the state in its search, which is not tantamount to the state accepting that the second party is the owner of the land. It's in dispute. In fact, since the records are opposite of each other, it's assumptive and presumptive, which leads rise to an equity court proceeding, not a law court proceeding, because no one has brought in any facts yet in law. When the first party, I called A, solicited party B to respond to their private administrative procedure, did B ever respond?
No.
No. Then what facts are true?
None.
Well, only by presumption are A's presumed facts true. Is that equity or is that law?
Equity.
That's equity. And when that A party failed to come into the state court, the state gave B a default judgment on failure to appear. Were there any concrete facts introduced in evidence in that case? No.
Equity.
So B presumes to have an interest. A presumes to have an interest. There is no claim by any party because there's no facts any place, both in private and public, with a double witness. If you go into this equity court in criminal proceedings, you will go to jail and you will pay a fine because there is no executional law to get you out as long as you stay in equity. Why, there was a charge, wasn't there? You bet. Well, we have to have someone to discharge the charge, don't we? You bet. That's equity. Otherwise, our books won't balance. What's that got to do with the true facts in the case? Irrelevant. We're not looking for the facts. We've got our mind made up. We're all here in assumption and presumption.
Do we know that man owns that property?
No.
We don't know it.
No, look, you're using the word own. Do we know that man owns that property? Ownership is pure commercial, and if you're ownership, you're a debtor.
Yeah.
Because the only way you can get ownership is through liability money, and if you claim to be an owner, you're a debtor. And if you're a debtor, you don't have control.
But we're on his side, right?
I don't know if we're on his side. He's a friend of mine. He screwed up in his process. He's got to make his own claims. He might be my friend, but I'm not going to go in and make a claim for him. It's not my business. Am I interested in explaining to him where he is screwed up and that he needs to get a life so that he doesn't go to prison for probably the rest of his life? Yes, it's my duty to try to explain to him, because he's my friend, where he went wrong and what he's got to do right. And thank goodness he is listening. That's incredible.
I don't know. I wouldn't want to go the rest of my life.
Well, this guy's already got like about 4 or 5 felonies in one state against him.
Oh, boy.
And he's in his 50s. You tell me when he's going to get out.
Yeah.
Okay? Let's look at another issue here. Think about the concept of going in and pleading guilty to the facts in a criminal case. There's a lot of people out there in Patriot land that have got a real mental block about that. And one of them is our friend back east, trying to think of his name, guy with the really deep voice. he cannot for the life of him accept this process of accepting the charge and pleading guilty to the charge, Howard Griswold. Because he said you'd be an idiot and a fool to plead guilty to a criminal fact charge. Okay? There's a lot of people that say, why would I plead guilty to the facts in the charging instrument on a criminal case? Isn't that like admitting that you're going to go to jail because you pled guilty? And the answer to that riddle is that when they charge you in a criminal case, you are an offender first. And if you join the defense team by arguing the merits of the case, then you're in partnership with the defenders, and then you're defensive. And remember, a defendant is a debtor. Now remember, debtors go to prison and creditors do not. So the question is, if you go in and plead guilty to the facts in a case, does that mean you're a debtor or does that mean you're a creditor? Well, we've had some people say creditor and some people say debtor. Remember, in the criminal case, one of the issues that you're looking at is the bond. And when it comes to the bond, if you're the holder of the bond, what are you, the creditor or the debtor? Creditor. If you're not the holder of the bond, what are you? The debtor. If you're not the holder of the bond, it's because it was a public bond bought and paid for with liability money, which means that the public now has title to the bond, and when you plead guilty, you are a debtor because you're being prosecuted under public policy, which is in admiralty equity, and the facts are on the moon. Just plead compromise because we don't care what the facts really are. And since the public holds the bond, you go to jail and work it off as a slave. What happens, though, if you're the holder of the bond? Aren't you the creditor? What does creditors do? They settle the dispute. Now, we talked about our friend up in Michigan. We talked about our friend down in Indiana today. If both of those parties go into their case with the UCC3 and assign the titles, i.e. ownership, to the other party, what are our friends, creditors or debtors? They're creditors. Because number one, they resolved the issue, didn't they? And number two, what was it that they were given by way of the UCC assignment to the other parties? Ownership. And the owner is the debtor. And they did bond it by the equity in the property. So, anybody that tells me that if you go in and plead guilty to the facts, you're an idiot, look in the mirror. Number one, if you argue the facts by pleading not guilty to them, you're fighting law and requesting equity. Now that you want to be judged in equity, what kind of facts and issues of law are you going to bring in to argue that's going to make any sense? None. Everything is backwards to the way you thought it was supposed to be. So you want to be the creditor in the substance by pleading guilty and the debtor in form by pleading guilty, and you'll come out perfectly okay. If you plead not guilty, you have elected equity as the jurisdiction of the court. You've said the rules, the facts, the law, the evidence is irrelevant, You're the debtor in dishonor under public policy. You will go to jail. I don't care what the case is. I don't care what the evidence is. I don't care what issue and argument of law you're raising. It's immaterial in equity. All we care about is just splitting the baby in two. That's all it is. So in reality, when you go in and say, I accept it for value, return it for value, and ask for settlement and closure, in some respects, when you haven't settled the substantive issues going on behind the scenes, all you are is a creditor in form. And a creditor in form and a debtor in substance will put you in prison quicker than a wink. And we've had enough of our patriots doing that. All we got to do is look back at what Joni and Richard did when they accepted return, asked for settlement, and it didn't do them any good because they did not go far enough to resolve the presumptions and the issues that were there. Now, we got a little time left. I want to announce that Victoria Joy is now out of jail. Believe me, no one is happier than she is. And although she's one of my dear good friends, now that she's out of jail, she's complaining about the probation terms. Her cup is always half empty. It is never half full. And so I will talk to Victoria about where that's going. But we are very pleased that she did get out of jail. Actually, I believe it was supposed to have been last Monday. She had her hearing late afternoon, and of course we're 3 hours later than them. We were having our meeting here on Monday night when she was having her court appearance in court to get out. She went to court. And actually, I think her attorney, the court-appointed one, is really getting to like her and understand her a lot more toward the end there. He was actually wanting to really get in there and fight. He actually, I think, almost could have hugged his client instead of being as mean as he was to begin with when she was doing all of those letter rogatories and stuff to him. And they got in front of the judge, and the judge and prosecutor were arguing about whether or not all of the so-called charges and cases against her were really, really, really settled. Like, hello, we're going to try to keep one of them and keep going or something. And her attorney jumped in and said, no, that's not what this was all about. The plea agreement for guilty was in exchange for settling everything. So the prosecutor and judge kind of mumbled and suggested that, okay, everything was settled, but this lady is a Montana Freeman-style person, and this lady is dishonorable and thinks she's above the law. And the prosecutor went on, just bad-mouthing our little girl for a long time. But then she got sent back to the jail, and they told her she was going to be dressed in street clothes and get out. So they dressed her in her street clothes, and she sat in jail till 3 a.m. in the morning. And she's kind of like steaming a little bit, going like, I thought I was supposed to be out of here. That was over 9-10 hours ago. And she asked one of the matron guards, what in the world is going on? And the matron guard went out and checked and came back in a little while and said, well, one of the court cases wasn't settled yet. And Victoria was really not very happy. And in the morning, because she was still there in street clothes, she called her attorney and said, what in the world is going on? And then she called me and told me this was a communist plot and they were going to kill her. And what's going on? And I said, Victoria, I get the picture. You really like jail and want to stay there for a long time, don't you? She goes, what do you mean? I said, don't you understand everything is a test? I said, why do you think they took you back to jail, put you in your street clothes, and let you sit in a cell until 3 a.m.?